everyone. Kindly please send me super thanks, subscribe, like, comment, and follow. This is what I've been talking about during my past interviews with Infotainment and Lelo_N, that the trial within trial is a waste of time unless it is done in the beginning of a matter. You cannot do trial within a trial in the middle of the main trial. Good afternoon, everyone, and you are welcome. In the times of myself and Advocate Defo, we fought in the first trial that the state should start with a trial within trial, because it will be the best and fair process. As it stands now, the state has already called most of its witnesses in the main trial. Probably they are only left with the lead investigating officer, Keninda, and Mashabane. Who knows? They might even forget and not call Mashabane, forgetting that they told the court they'll call Mashabane. The Honorable Court used the old case laws before the Constitution, which is fair according to what things has transpired, because it is a case law that in the trial within trial, only a ruling is made until the whole matter is being finalized. So meaning that many people were caught by surprise. What the Honorable Judge said today at the end of the proceedings. I even suggested that he might come up with the outcome on Wednesday or Thursday, of which he opted for Thursday. The Honorable Court was even nearly tempted to give the judgment today. And it gave us hints which direction will this judgment take. However, I still maintain that this trial within trial is in violation of the Constitution. It is in violation to the principle of fair trial, because it will be the defense witnesses who, most of them, are going to testify. And this principle of trial within trial will be tested in towards most of the defense witnesses, because most of state witnesses had already testified. Unless Advocate Mgomezulu throw a spanner and say to the Honorable Court he wants the state to reopen its case and call all those witnesses which the state called in the main trial, because by that time Advocate Mgomezulu was not party to the proceedings, and his style and style of that legal representative who appeared during that time, they are not the same. He's got his own style of cross-examining, and it will lead to the matter starting afresh in the main trial, whereas the ruling of trial within trial will still be there, awaiting the outcome of the main trial. That is how the Criminal Procedure Act 51 of 1977 was used as an instrument to suppress the majority in this country, to get or find the majority guilty by hook or by crook. Hence, I humbly submitted that it is a mafia-style law of evidence. It's a mafia-style criminal procedure, Act 51 of 1977. Because honorable courts are allowed to refer to case laws which came before 1994. Even if it's a case of 1928 or 1911. However, as a legal representative, you must be able to stand your ground and argue. You must argue whether that case law of 1911 or of 1928 pass the constitutional muster. It is very important whenever a case of pre-1994 is referred to, it must be interrogated to check if it was handed after 1994 was still going to be applicable. Just like this Criminal Procedure Act 51 of 1977. It has been amended on several occasions, but some of its sections which are unconstitutional are still retained. Hence, there was this conference, the National Conference, whereby they are discussing the amendment of the Criminal Procedure Act 51 of 1977. This conference was held 2 or 3 weeks ago. What the Honorable Court said today, it sounded like a bombshell to most people and to a surprise to even including legal practitioners. And now they sit there and listen and watch the Honorable Court addressing them. I hope when they come back on Thursday, they'll argue that this will render the trial unfair because the state had already called most of its witnesses. And this principle will only apply to the defense witnesses who will be tested in the box. State witnesses had not been tested in the box with regard to this ruling of trial within trial. Let's say, for instance, the Honorable Court ordered that made the ruling that the trial within trial, that the confessions are inadmissible. It doesn't mean that it's a final ruling. It doesn't mean that it's a final judgment. It means that they must go to trial, to the main trial, and still the state must try to prove its case beyond reasonable doubt. But the Honorable Court will go back and refer to evidence in trial within trial, and at some point overrule its ruling in the trial within trial. Same goes when the Honorable Court will say trial, the confessions in a trial within trial are not admissible. Whether it means that whether they are admissible or not admissible, they still stand to be scrutinized in the main trial, wherein most of the witnesses will be from the defense side, which leaves us in a conundrum, in that we are obliged, if we want to take that route, to go to another court to compel the NPA to make a decision on Docket 375, or to come before this honorable court to compel the NPA to make a decision on Docket 375. When I say decision, I mean to say they nolle prosecute the case, or they are going to prosecute on the case, on the Docket 375. If it happens that they prosecute on the Docket 375, it means there might be another trial concerning that docket. Alternatively, the state may make an application for it to add other accused on this matter, 636. However, it must be noted that in the Docket 375, a visible charge there is defeating the ends of justice. A prima facie charge is defeating the ends of justice and accessories after the effects. The issue of whether whoever was in the house or this accused may be charged with murder, it means that if they charge them with murder, those people who were in the house as well, it means this Docket 375 must be combined with 636, and they both brought together before this honorable court. The catch-22 situation here is that in Docket 375, there are those who stand a chance to be only charged with defeating the ends of justice and accessories of the effects. Therefore, should the state decide to bring everyone together in one courtroom, then others will face different charges from some of them in this instance. If everyone can recall, in my previous interviews, I stated that the trial within trial, it will be a waste of time and a tactic on behalf of the state. If the state really wanted to play their cards open, they should have started with trial within trial. And the Honorable Court, there's nothing it can do because it works on precedents. It works on case law. Remember, this is not an act of parliament. What the court is talking about is case law, is precedents. It has some kind of influence in future proceedings. Hence, they call it a precedent. Unless someone out there or amongst the legal representatives before this honorable court challenge, that case law based on the fact that the judgment was made before 1994 and it will never stand the constitutional master, as it will render the trial unfair on the following basis. The state had already called most of its witnesses, and the defense is yet to call their witnesses. It will have a negative impact on the testimonies of the defense witnesses in the box. And an inference that may be drawn might be unfair, and which lead to rendering the trial unfair. So, hence, we always say in law, there's no wrong answer, and in court proceedings, we are dealing with technical issues, point of law, and common law. Point of law, it includes precedents and Act of Parliament. In CASU, the court concentrated on precedents, judgments of the past when they dealt with trial within trial. It must be noted that whatever the ruling will the court hand down on Thursday, it doesn't mean that it will be the end of the state case or the defense case, because that ruling is temporary. It still have to be made a judgment, and nothing stops the court from deviating from that ruling based on what will be led in the main trial. However, it puts the state in an advantage position because it had already called most of its witnesses. However, if the state feels that they are being disadvantaged, they can also make an application on their own. The state can make an application for reopening of its case in the main trial, even though its case is not closed, meaning they can make an application for recalling of the witnesses. As a seasoned legal representative, when you come into a trial, when you come to a matter whereby the trial has already begun and you are in the middle of a trial, and some of the witnesses are already being called, and you didn't have an opportunity to cross-examine those witnesses, it is within your right to make an application that those witnesses must be recalled, because you don't want to be seen as someone who doesn't know what is doing. You don't want to be seen as someone who is not prepared to conduct the matter. Remember, the public must remember that whatever the attorney or legal representative must do must be done in the best interest of the client. I hope you understood me and it's very clear to everyone. It's not a train smash. It's not a train smash. We're still well within the process of trying to find justice for everyone in this matter. Because justice is not only one-sided. Justice is two ways. I thank you very much and have a good evening. If you have any questions, kindly please post them on this video and I'll reply. I thank you.